Welcome to Sakshi TV special immigration show with attorney Vishal Iyar. Please note that Sakshi TV now has 3 immigration shows every week. On Thursday at 5 p.m. EST with attorney Chand Parvatneni, on Wednesdays at 5:30 p.m. EST with attorney Prashanti Reddy in English, and on Friday at 6 p.m. EST with Banu Nidra. Please tune in to ask your questions. If you are an immigration attorney and would like to join our special shows, please email us at usa@sakshi.com or call us at 8667257441. Before we begin the show, please note that the information provided on the show is not legal advice and for general informational purposes only. Sakshi TV or its agents will not be responsible for the use of information. If you need specific legal advice, please contact the attorney directly. Iyar LCC is based in Houston and proudly serving many other parts of USA. Their firm handles family law cases and also takes immigration cases nationwide. Whatever family law or immigration law issue you have, they would be delighted in helping you craft an aggressive strategy that is tailored to your precise legal needs. That's why they help clients dealing with a wide range of immigration and family legal matters. So without any further delay, let's call Mr. Iyar himself. Hello, Mr. Iyar. I hope you're doing well.
I'm doing well. Nice to thank you for inviting me.
Thank you so much, Mr. Iyar, for joining onto our show. It's wonderful having you. So before we get into the topic, I thought maybe, you can talk a little bit about yourself and what your law firm does in USA.
I'm an immigration lawyer largely. I also do family law. For family law, we tend to practice on all areas of marriage, divorces, child custody. For the immigration side, we do a lot of family-based immigration cases. We do a couple employment-based cases. We do extraordinary ability, multinational executives and managers, and a couple of the non-immigrant visas. We do naturalization, and we obviously do all sorts of removal proceedings for anybody who finds themselves in hot water in the U.S. immigration system. We kind of consider ourselves problem solvers, ultimately.
Yes, that's great. So, Mr. Iyar, I thought we will get on to our topic. Our topic is basically, there are these common FAQs that we get, now that in our channel, we have many social media platforms, and these are one of the most common FAQs that they get. And I thought we'll discuss a little about it. So the first question is, Mr. Iyar, what is citizenship by naturalization? Can you explain a little bit about what exactly is naturalization and how does citizenship come with it?
Sure. So in the United States, there's only 2 ways to obtain citizenship. The first and the more common way is just by birth. So if you're born in certain places or to certain parents, you automatically acquire citizenship, by the time you enter this world. But for anyone else, anyone who doesn't become a citizen at birth, the way you become a citizen is a process called naturalization. And the requirements for naturalization obviously vary depending on what kind of naturalization you have.
So, Mr. Iyar, what is the current time for becoming a citizen by naturalization once applies?
It's actually gotten a lot faster. So if you asked me a year ago, it may have been up to a year to get approved. But recently we've had decisions within about 3 months. So they have really sort of expedited this process. And for this question, a lot of it depends where exactly you're applying. So I'm in Houston, Texas, which is one of the biggest places for immigrants in the country. And so our timelines may be a little bit longer here. If you live in a smaller city, it may be a little bit quicker, but in my opinion, it's going pretty fast everywhere in the country. So I'd be surprised if it really took more than a couple months anywhere.
So, Mr. Iyar, how much does it cost to apply for citizenship by naturalization? Does that differ from one person to another or maybe one state to another? Can you, briefly explain a little about it?
Sure. So there's a fee for naturalization from the government. I think that's a little bit more than $700. Maybe it's around $725 right now. There is a fee waiver for people who make below a certain amount of income. There is a half fee waiver for other people. I mean, the fees are going up in general. The government has proposed increasing fees by about $500 for everybody, but that hasn't come into effect yet. So right now, generally $725. That's sort of just the government fees, though. On the other hand, there's also lawyer fees, and that may depend on how complicated your case is. So just because you apply for naturalization doesn't mean you actually get it. Some people, when they apply, they're instead placed into removal proceedings. So the type of naturalization case you have can definitely become complex. And so from a legal perspective, there may be higher fees for some of the more complex cases. But the government fee kind of just usually depends on whether you're eligible for a fee waiver.
Yes. So Mr. Iyar, can you tell who exactly is eligible to apply for citizenship through naturalization?
Sure. So for naturalization, there's actually two groups of people. There's certain people who naturalize automatically. They don't even have to file an application. For example, children under the age of 18, they automatically naturalize once one of their parents becomes a citizen. So leaving aside automatic naturalization, to apply for naturalization in general, you have to be at least 18 years old. You have to have been a citizen for at least 5 years. And then you have to have been a permanent resident for at least 5 years. So there's kind of a waiting time. However, as in most things, there's usually exemptions and waivers. So the 5-year waiting period is reduced to 3 years if you're the spouse of a US citizen. There's even faster ways to naturalize. You can naturalize in 1 year. If you join the military, the US military, there's even more niche ways to naturalize that potentially could be even faster than that. But those are increasingly rare. For the vast majority of people, you're either in the 5-year period of being a permanent resident, 3-year for marriage to a US citizen, or 1 year for military naturalization. But those are really, that encompasses most people.
Yes. So, Mr. Iyar, apart to 3-year or a 5-year waiting time after getting the green card, what are the other main requirements one should meet to be eligible to apply for citizenship?
So in general, when you apply for naturalization, as a threshold issue, you have to be over 18 years old. You can't have been a military deserter. You have to, be a permanent resident. Your permanent residence had to have been approved lawfully. So some people, they may have gotten their permanent residence through a mistake or through fraud. Those people won't be eligible. As you mentioned, you have to have had your permanent residency for at least 5 or 3 years. You have to have been continuously resident in the United States during that time, which doesn't necessarily mean you were in the United States the whole time. It's just that you were maintaining your principal residence in the United States the whole time. You also have to be physically present in the United States for at least half of that time. So it's either 2.5 years for the 5-year people, or 30 months for the 3 years people. You just have to be physically present in the United States for half of that time. And finally, and usually what's the biggest issue in most cases, is you have to be a person of good moral character, which kind of depends on your criminal history, your sort of family relationships. It even goes down to like whether you drink a lot of alcohol, So all sorts of things are considered in the good moral character analysis. But in general, once you meet all of those elements, you're eligible for naturalization.
Yes. So, Mr. Iyar, was hoping, can we talk a little about the divorce and the family laws that you deal with? So, first of all, this is a very common thing that happens. The spouse is on H-1B visas, and the women, or the other one is on the supporting visa, and they want to get divorced. So let's say somebody is on H-1B visa and they are getting divorced, and they're not yet the citizens of the country. In what ways can they get the divorce filed, and what according to you can happen?
So, what you mentioned is fairly common when you have the principal non-immigrant who may have an H-1B or any sort of visa that gives benefits to the spouse. And then for an H-1B, the spouse would have an H-4, and the H-4 is that spouse's status in the country. So the status is purely as the spouse of someone else who has been invited to the country. So once you remove that family relationship through divorce, there's no longer that same basis to remain in the United States in H-4 status or in whatever other spousal status. If you need to get a divorce, get a divorce. Sometimes it's necessary, but you may have a follow-on immigration problem in that after the divorce, what do I do now? You may have to do a change of status to something else. You may not have any sort of status that you can easily go to, and you may not be able to remain in the United States long term after that. So, obviously divorce can cause not only kind of problems between the couple that need to be resolved between themselves, but it may also have follow-on immigration consequences that lead to the spouse having to leave the United States. That said, oftentimes I think people may want to stay in a relationship that's not great for the immigration benefits, and you just have to make clear that there's a lot of, you shouldn't suffer like domestic violence or abuse or anything to stay in some sort of these relationships, and if that's the instance, you may have separate immigration relief anyway. So, each situation is different, right?
So, Mr. Iyar, are you saying that, if a kid is involved, let's say a child is involved in a specific divorce case, how different is that going to be? Because let's say that the child was born in USA, and what kind of benefits, or what kind of things can happen when the child is involved between a divorce?
So, it changes everything. So you go from a matter just between two people ending their relationship to affecting a lot of the core rights of a child. So the court, the family court takes those cases a lot more seriously. For children, the court has to make a number of determinations. They have to determine what parent gets custody, if there's child support involved, if the parent which parent gets the right to apply for a passport. all sorts of things can come into effect. That's kind of distinct from the immigration analysis. So, say you have the father is an H-1B, the mother is an H-4, and the child is a U.S. citizen. All three sort of have different immigration statuses, and it's kind of each one has to think about immigration on their own. It can get a little complicated.
Yes. Now, Mr. Iyar, I thought we'll get on into what is deportation. So deportation is the popular topic nowadays. So what exactly is deportation, and what kind of people are generally deported from USA while they're living in the country?
So deportation is, it's big. It's just like the US deportation machine is huge. There's all sorts of ways that you can be removed from the country. I think probably one of the more common ones is you enter the United States on a plane at the border, and the CBP officer at the border says that, we don't think these documents are right, you don't have documents, and you may be subject to expedited removal, which can happen very quickly. Additionally, there's, if you've been here a while, maybe you overstayed your visa, maybe you violated your visa, you entered on a visitor visa and you worked when you weren't supposed to. Like, violating the terms of your visa can also subject you to removal. More commonly, I would think a lot of people in removal proceedings are also people who have already obtained permanent residency. You already have H-1Bs. So for permanent residents, you can be deported if you commit certain crimes, if you violate some other laws. It's usually crimes or like terrorism-based things. You say you're a permanent resident, you're convicted of certain crimes. Not only will you have to deal with the criminal consequences, you will also have to deal with follow-on immigration consequences. And those can be very difficult because immigration has its own set of detention laws in addition to the deportation aspect. So it can be very difficult, but oftentimes there is a solution to all of that, and it's important that you really prepare for those cases, because you really have one chance. And after removal, it can be much more difficult to fix it.
So, Mr. Iyar, what kind of criminal acts cause deportation in general? Like, what are the common most criminal acts that cause deportation?
There's a lot. There's a lot. Aggravated felonies are some of the harshest consequences in immigration law. Those kind of bar you from most forms of relief, and that's a ground of removal. There's also what's called crimes involving moral turpitude, which is kind of a fancy legal term that involves certain issues. Controlled substance violations. So if you violate like illegal drug laws, even things that are legal in many states, like marijuana in the United States these days, it's legal in some variation in most states at this point. Yet it's still illegal federally. So marijuana violations can get you deported too. But regarding, what sort of criminal laws, we're talking about aggravated felonies, crimes involving moral turpitude, which encompass a huge range of crimes. So a crime involving moral turpitude is, it usually just involves something that involves like fraud or theft or, some other sort of act that is considered inherently depraved. But that can be all sorts of things, that can be like riding a bus without paying the fare. That's theft. That's theft of services. You can get deported for that, so we're not talking about a huge bar here. We're talking about theft of 25 cents can get you deported. It depends on the nature of the crime, whether there's a conviction, whether there's a mission. It depends on a lot of things, but the range of crimes for which you can get deported is enormous.
Yes. So, Mr. Iyar, can you explain us what does an aggravated felony mean in immigration deportation context? In what context? And can you explain that?
There's so many contexts. It's really just, aggravated felony is a defined term, and it just involves, I think they're up to like 23 different categories of aggravated felonies. There's aggravated felony for for murder. There's some for as harsh as murder, or even as little of an offense as just like some drug possession crimes are aggravated felonies. So it's hard to know what exactly is an aggravated felony, except for just sort of like researching it under case law, because the same sort of offense in two different states, one could be an aggravated felony under immigration laws, the other may not be. It's kind of hard to talk about at a broad level when it's really kind of, you have to do the case law research for each individual crime.
So, Mr. Iyar, can you explain what exactly is crimes of moral turpitude and how does it impact visa holders or green card holders?
Well, so as we mentioned, crimes involving moral turpitude usually involve fraud, theft, or some other form of inherently vile or depraved behavior. But that's a very sort of high level definition. And again, this is something that you really just have to go into the case law to figure out what sort of crimes are CIMTs. But in general, theft offenses are almost always CIMTs. And so whether you're stealing, $10,000 or you're stealing 25 cents, all of that could be a CIMT, and all of that could jeopardize your immigration status. I think the takeaway for immigrants, for all immigrants, is that, your right to be in the US is not the same as a citizen's. You can be removed on things that for a citizen would get you a slap on the wrist. But at the end of the day, you have to be more perfect than everybody else. And so it really sort of behooves you to be on your best behavior until you become a citizen, because even after you obtain permanent residency, you can be deported. And those cases happen all the time.
Yes. So, Mr. Iyar, are there any other non-criminal issues that can cause deportation and removability from USA?
If you help people enter the United States illegally, by giving them money or by giving them, support in any ways, that can be a reason for removal. if at the time you entered, maybe you concealed some information. So at the time you got your green card, say you hid some information and the government finds that out later, that can be another reason to sort of reopen the process and put you in removal proceedings. Let's see, if you can be removed for domestic violence. You can be removed for being a drug abuser or addict, for failing to update your address with the immigration authorities. Even that's a ground of removal. High-speed flight from an immigration checkpoint, that's another one. Firearms offenses. So in the US, we like firearms a lot. They're legal in all sorts of ways, but if you violate even the smallest law regarding firearms, you'll be subject to removal, even if you're a permanent resident. Human trafficking is another. There's a whole bunch of national security offenses. If you violate a protective order, if you commit document fraud, if you become a public charge, if you vote unlawfully, if you claim to be a US citizen, there's all sorts of things that can get you removed. Really, I try to encourage my clients to become citizens as soon as possible because there's just so many ways this process can go wrong if you sort of just like stay as a permanent resident for a very long time. So once you become a citizen, all this is largely behind you. You're largely not subject to removal anymore. But until then, like stay on your best behavior.
Yes. So, Mr. Iyar, while I was going through your website, I also saw that there was one service that is called as premarital agreements. So, can you explain our viewers a little about what is the specific service that you are providing in USA?
When you get married to someone in Texas, you are kind of buying an off-the-shelf contract that the government has written. The government sort of says, here's the rights between the spouses, here's the rights for who gets money in the divorce, here's the right for like children. They do talk about children, but they talk about all sorts of like off-the-shelf rights. You do not have to sign that contract. You can create a bespoke contract between you and your spouse that accounts for both of your objectives, both of your, like risk tolerances. There may be a number of reasons why you want to modify the government contract. The premarital agreement is just sort of you two coming to your own agreement on how you want to resolve things in the event of divorce or some other specified event. But it sort of helps the parties protect their assets and have some more certainty when going into an immigration process. And I mean, let me just give you an example, right? So in many family-based immigration processes, one spouse petitions for the other spouse. And as part of that process, the petitioning spouse also has to execute an affidavit of support contract. What that means is that spouse, the petitioner, is essentially promising to the government that if the beneficiary ever, after coming into the US, starts using like US welfare programs like Medicaid or food stamps or something like that, that the petitioner will reimburse the US government. And so that can be a very, very onerous obligation. I mean, you may have to reimburse millions of dollars. It can be very, very serious. So in the premarital agreement, in addition to setting all sorts of other, how you want to manage financial affairs between the two future spouses, one thing that you can do is sort of you can talk about, the affidavit of support rights between the two parties, whether the beneficiary will agree to surrender the right to sue the petitioner in a later proceeding. So you can talk about all sorts of things. But in the immigration context, particularly in the family immigration context, I think it makes a lot of sense because these affidavit of support contracts are so onerous for the petitioner. Not only are you taking this huge obligation to the government of reimbursement, but that contract is also enforceable by the beneficiary. So if the beneficiary at the point of divorce decides to enforce that contract, I mean, you can be out, hundreds of thousands of dollars. So all of these things are things that spouses should be considering before marriage because you can sort of just get better clarity as in your financial exposure if the marriage goes wrong.
Yes. Finally, Mr. Iyar, is there anything that you want to say to the viewers watching the show right now?
Well, I mean, thanks for watching. If you need any immigration or family help, we're more than happy to help you. We're in Houston, and we do consults nationwide in the U.S. We also do take foreign clients if you're applying for a visa at a consulate, U.S. consulate or embassy. So, if possible, let us know if we can help you.
Yes. Thank you so much, Mr. Iyar, for joining on to our show. We did have an amazing time. I really enjoyed it. Thank you for the viewers for tuning in. You're watching Sakshi TV with me, Shivani Raj.